Good morning, everyone, and welcome to part 3 of our 3-part webinar series on trending events in education law, a 3-part legal and legislative update series. My name is Susan Anderson, and I'm a shareholder at Roetzel and Andress, and I'm the chair of the Education Law Practice Group. This webinar is being presented by the Education Law Group at Roetzel and Andress, as well as Roetzel Consulting Solutions. In part 3 of this webinar, we will be discussing the status of numerous bills that have been either recently passed or are currently pending before the Ohio Legislature in this lame duck session. We will be discussing Senate Bill 104, commonly referred to as the bathroom bill, and we'll also touch upon House Bill 8, the Parents' Bill of Rights, as well as Senate Bill 29 and Senate Bill 293. So if you've attended our prior sessions, you know that we've been tracking these bills for some time now as they've been pending through the legislature. And the intent of this webinar this morning was to be able to inform you all of the final form of those bills. And we had expected that by now on December 18th that the legislature would be done with this lame duck session and we would have final forms of these bills. Well, the Ohio Legislature did not cooperate with our timeline, unfortunately. And so, as you may have heard on the news, there is a session scheduled today, the final session in the lame duck legislative session. So we will be discussing the current status of most of the bills with our predictions of what will happen with those bills today. But please look in your inbox after today for an update as to where those bills ended up landing after today's session. Okay, so the schedule for today is we're going to start talking about House Bill 8, about Senate Bill 104, the bathroom bill. And I will be speaking about that as well as Sherry Warner from Roetzel Consulting Solutions. Sherry is a director at Roetzel Consulting Solutions, as well as a shareholder and attorney for Roetzel and Andress. And then we will turn it over to David Hurt to discuss the current status of House Bill 8. David is a shareholder at Roetzel and Andress, and he works out of our Akron office. And then we will move at 10:30 to the current status of Senate Bill 29 and Senate Bill 293, which will be discussed by Aaron Ross, an associate in our Columbus office of Roetzel and Andress, as well as Sherry Warner. And really integral to all of this discussion is our own Sherry Warner, who is again a director at Roetzel Consulting Solutions, and she's had her fingers on the pulse of the legislature during the pendency of all these bills. So she will be the one, she's the one in the know of what's happening with these bills and what may happen yet today. So she will be helping to drive the conversation on all of these topics. If you have questions, we will address those questions at the very end, and please just put those in the chat box and we will pull those up and we will address the questions. So before we get started on the bathroom bill, I'm going to turn it over to Sherry Warner to talk about what is going on with the Ohio Legislature today and what we can expect to happen from here. Sherry, it's all yours.
Thanks, Susan. So we are waiting right now for the Senate Education Committee to come into session. They have 3 bills on their calendar. House or Senate Bill 295 is the closure bill. That bill is off the table and will not be addressed in this General Assembly. Don't cheer too loudly, though. I do expect it to come back during the budget bill next year. The other 2 primary focuses are on House Bill 8, which is known as the Parents' Bill of Rights. It has also had the religious release time bill amended into it. And then also House Bill 106, which will allow superintendents the flexibility to suspend or expel students for extended periods of time after there's been a serious threat, and then outlines ways for those students to come back into and start attending classes with their schoolmates again. So, as Susan said, the first part we're going to do is an update on Senate Bill 104, the bathroom bill. This bill is effective on February the 25th, 2025. So this is one of those that is done, and what Susan tells you is what steps you need to take to be in compliance. And with that, Susan, go ahead.
Okay, great. Well, as Sherry mentioned, the Senate Bill 104 is effective February 25th, 2025. It was signed into law by Governor DeWine on November 27th, 2024. And what the bill does primarily is it enacts sections of the Ohio Revised Code 33-1990, addressing primary and secondary schools, and then 33-45-90, addressing higher education as it relates to the designation, use, and control of bathrooms and locker rooms in school facilities. There are some components of the bill that also address College Credit Plus, and we'll talk about that briefly at the end of this discussion. So, it's called the bathroom bill for a reason. What this bill does is it requires that each student restroom, each student locker room, changing room, or shower room that is accessible by multiple students at the same time be designated for the exclusive use of students of either the male biological sex or the female biological sex. So your multi occupancy bathrooms and locker rooms, changing rooms, shower rooms that you have in your school buildings or school facilities, those have to be designated for one biological sex or the other. This bill does also address overnight accommodation. So it reaches the issue of what to do about field trips. And so the bill also prohibits male and female students from sharing overnight accommodations with members of the opposite biological sex. I should note that this bill is applicable to school districts and to school district buildings. It's also applicable to community schools, and it's applicable to STEM schools and ESCs, as well as chartered non-public schools. And the restrictions and mandates of the bill apply to school districts and school buildings, but also facilities used by schools for school-sponsored activities. So keep that in mind as well. So the bill centers around designating, shared locker rooms and restrooms for one specific biological sex exclusively, and it does define biological sex. And I will tell you, trigger warning, there is a reference to gonads in the definition that you'll see on the screen. It might be a little early to talk about that this morning, but biological sex is the definition is centered around what it calls a biological indication of male and female. So it's looking at sex chromosomes, naturally occurring sex hormones, non-ambiguous internal and external genitalia present at birth. And it specifies that this is focusing on the physical and physiological without regard to an individual's psychological, chosen, or subjective experience of gender. So in other words, it's defining biological sex without regard to a person's gender identity. The bill does specify that the birth certificate may be used to prove biological sex, but that birth certificate must have been issued at or near the time of the person's birth. So that is meant to exclude birth certificates that may have been legally changed to accord with someone's gender identity, later in life. We'll talk about, this bill has a pretty straightforward mandates and restrictions in it, but really the impact of the bill is in what it doesn't say or what it doesn't address. And this is a key, one of those key components that it doesn't address. So it doesn't address what you do if you have a student that may have been born intersex with, sexual characteristics or sexual genitalia of both sexes. This bill is silent on that issue. In that case, I think you would want to ask to see the student's birth certificate to see what sex was designated for them at the time of their birth, and that would be one approach to take on that issue. Okay, so what the bill says is, the mandate is a school shall designate each multi-occupancy restroom, locker room, changing room, shower room you know, multi-occupancy, meaning accessible by multiple students, must be designated for the exclusive use of either boys or girls, essentially. And then, you know, that seems pretty clear, but then the bill also takes it a step further to say explicitly that a school shall not permit members of the opposite biological sex to enter into the facilities designated for the other sex. So in other words, it is saying to you, school, you must designate it as either a boys' restroom or a girls' restroom, and you cannot permit a member of the opposite sex to enter into that facility if they're not a member of the biological sex to which that facility is designated. So one question that we've gotten is, okay, so does that just mean, you know, during the school day, what about outside clubs that may be renting space or just using space at a school building? And I think here the language of the bill is instructive because the bill does contain references to students, but in terms of the restriction about not permitting members of the opposite sex, what is the term used there is just members of the opposite biological sex. So the bill explicitly says a school shall not permit members of the opposite biological sex to enter into facilities designated for the other sex. So that to me signals an intent that this isn't just the restriction is not just centered on students during the school program, but if the facility is open to other clubs and outside groups, that these restrictions must also be enforced as it relates to their use of the school building. Okay, so we've already discussed the school may not have multi-gendered, multi-occupancy rooms, but the bill does specify that a school may have a family facility, and a family facility is defined in the bill as having only one toilet or one shower. So that is, you know, that is a bit of a workaround available to districts to, you know, have their multi-occupancy restrooms and locker rooms designated for either boys or girls exclusively, but then also have a one toilet, one shower, bathroom or locker room facility that may be a family facility used by both genders. The bill also does specify that a school may accommodate a request by a student through the use of single occupancy facilities or controlled use of faculty facilities in special circumstances. So, and here's where I think the language is instructive. So what it specifically says is that a school may establish a policy to provide accommodations such as a single occupancy facility or a controlled use of a faculty facility at the request of a student due to special circumstances. So, you know, what that sentence essentially means is number one, you have to be looking at developing a policy so that you have a policy in place to address accommodations when they are requested. Number two, that makes clear that the accommodation must be requested by a student. So that kind of takes out from consideration kind of a school being maybe proactive and addressing perceived issues that a student may be having with using the restroom designated for their biological sex. The trigger has to be a request from the student. And then the request has to be for an accommodation due to special circumstances. So again, one thing that the bill doesn't answer is what is a special circumstance? And so I think that does give the school some leeway to think about what special circumstances it will accommodate. The use of perhaps a single occupancy restroom or a faculty restroom for a student. And you should be thinking about that as you're developing your policy and referring to special circumstances. But I think, you know, uh, schools are going to know because they've been dealing with it for a number of years now. The most likely scenarios where students are coming to them to say, hey, you know, I'd like to use a restroom that's not designated for my biological sex. I mean, you've been dealing with those kind of requests for a number of years now. So I think you can kind of foresee what the circumstances of those requests may be. But I think when you're developing a policy, you want to make sure that there is it's a general catch-all to that. So you're not so narrowly defining special circumstances that you might be stuck with a policy that doesn't actually address the special circumstance that is being brought to you by a student in your day-to-day operations. Okay, there are exceptions to the prohibition of not accessing a multi-occupancy bathroom by the opposite biological sex. Those exceptions are a child under the age of 10 who is assisted by a parent, guardian, or family member may enter into a multiple occupancy restroom or locker room that's designated for the opposite biological sex, and the bill makes clear that the person assisting that child also has authorization to do so. Also, a person with a disability who's being assisted by another person is permitted to enter into a multi-occupancy facility that may not match their biological sex. Another exception is school employees whose duties require the employee to enter a restroom, a locker room, changing room, shower room. So this would be like your custodians or your maintenance personnel or your educational aides who may be required to accompany a student into a restroom. And then there's also an exception for an emergency situation. So a person who enters a facility that's designated for the opposite biological sex because the person reasonably believes that the person is responding to a legitimate emergency. So again, this bill provides some answers in terms of what a district's responsibilities and obligations are when you get student accommodation requests for the use of a bathroom that does not accord with their gender identity or with their biological sex, rather. But what it doesn't do is it doesn't answer the question of how districts address what they are required to do under the state law with the requirements of federal law. And so I have no doubt that our audience is familiar with the Title IX amendments, the 2024 amendments, and even before that, Title IX was thought to cover gender identity, and with the 2024 amendments, that Title IX was amended to even more specifically state that the Title IX protections do apply to a person and consistent with their gender identity. Those federal amendments in Ohio have been enjoined by the court. So OCR and the U.S. Department of Education is enjoined currently from enforcing those amendments. So that provides, I guess, some wiggle room for schools to comply with state law. And if they are accused of not, by their compliance with state law, if they're accused to not be complying with federal law. Number one, that those specific amendments are not being enforced right now in Ohio, so that gives us some breathing room to know what will happen with those. However, you are kind of just stuck with the situation of having to say, look, we're complying with the direct state law on the topic, but you may be open, this may open you up to students claiming that you're violating their federal civil rights, either through the Section 1983 action or the state law that also prohibits violation of constitutional rights. So the school may be open to those this does open the school up to some degree of potential legal action on that. The answer to how that's going to flesh out, we don't know yet because it will have to be tested in courts. The other thing is with the change in the presidential administration coming up, there very likely could be a rollback of the 2024 Title IX amendments that were issued under the Biden administration. So there's a lot that we just essentially need to stay tuned on. But, for now, we have a direct state law that provides pretty explicit instructions on the use of bathrooms by students. And so, this is an issue that districts should be looking at complying with, for the foreseeable future. There are some college credit plus provisions in the bill. I think some of the most impactful to school districts is it does add a November 1 application deadline to existing law. So in other words, a student may ask by November 1 to participate in college credit plus for the next semester, rather having to do it in April of the prior year for the next year. Schools have to use designated college credit plus forms. There is a provision for mandatory orientations of students, and that must be given by due or the college. And then another one that's probably a little bit more impactful for students is, or for school districts rather, is that there will be, the state report card will now include what I understand to be kind of a checkbox of whether or not the school fully promotes college credit plus in its programming. So, you need to consider that in what you're doing in terms of rolling out your college credit programming to your students. And that is all I have on this topic. I'm going to hand it over to Sherry Warner and David Hurt to speak about the Parents' Bill of Rights.
So before David gets started, let me fill you in where we're at right now with this particular bill. House Bill 8, known as the Parents' Bill of Rights, passed the House and is now sitting in the Senate Education Committee. There were sub-bills introduced in the Senate Education Committee, which expanded definitions around what could and could not be taught in the schools. And then also they amended in last week the Religious Instruction Bill, which will require your districts to have policies regarding release time for religious instruction. The bill has not moved out of committee. The speaker has indicated that he would prefer to have what he's calling a clean bill, or a bill with no amendments, or at least no additional topics like religious release time, passed back to the House. It is a priority bill for the House. You can see that with it being House Bill 8. It was one of the first 10 that were introduced. So they felt that this was a very important topic. So he would like to get it done this time, but he wanted a clean bill. Last week, he did indicate that they would not bring the bill up if it had release time in it. He has since walked back those comments. So as of right now, the bill sits in Senate Education Committee. The committee is in recess at the call of the chair, and we anticipate the committee voting it out, it going to the Senate floor. The Senate will pass the legislation, and then we'll have to see if the House concurs. That should happen sometime between now and whenever they finish their last session of the year, which could be at 8 p.m. tonight. It could be at 3 a.m. tomorrow morning. So we'll have to wait and see. But with that, David is going to talk about the way the sub-bill exists right this minute. If we happen to get any notification that there's been additional amendments during this webinar, we will let you know. And if we don't get those notifications, please watch for information in your inboxes over the next 24 hours, as we will get that information out to you as soon as we have it. So David, go ahead with House Bill 8.
Thank you, Sherry. Next slide, please. So the Parents' Bill of Rights, the original House Bill 8, creates a new section of the Ohio Revised Code, and it contains some very general language in it that I think may have some unintended consequences, and it may be a tool for parents to use in litigation in the future. But there's a statement that the General Assembly believes that a parent has a fundamental right to make decisions concerning the upbringing, education, and care of the parent's child. And so, this is a little bit different from what court cases have stated in the past about controlling the child's education. Generally, what courts, including the U.S. Supreme Court, have held is that a parent may have a fundamental right to decide whether to send their child to school or not, But if the parent decides to send their child to school, then it is up to the local school board to address the child's education. And of course, Ohio law already has many exceptions to that, but this general language, may be a little bit troubling and cumbersome, difficult for school districts in the future. Next slide, please. So House Bill 8 says basically three different things, plus we'll talk about the addition of release time for religious instruction. But one of the premises of House Bill 8 or provisions of House Bill 8 is that a school district must ensure that any sexuality content, which is a legal term of art, is age appropriate and developmentally appropriate. Now, the current version of House Bill 8 before the General Assembly also contains a prohibition that a school district shall not provide any instruction involving sexuality content to grades K through 3. So the General Assembly is deciding for you that no sexuality content is appropriate for children in grades K through 3. House Bill 8 also contains a provision requiring district personnel to notify a parent of any change in the student's services, and then more importantly for our purposes, any change to the child's mental, emotional, or physical health or well-being. And that is also a legal term of art, and we'll see how that phrase, student's mental, emotional, physical health, or well-being, is defined. And if there's a change to that, the district personnel will now be required to notify the parent of that. And then House Bill 8 also prohibits district personnel from suggesting, encouraging, either directly or indirectly, a student to withhold from his or her parent information concerning the student's mental, emotional, or physical health or well-being. And again, that's the legal term of art with an important definition. Next slide, please. In terms of the restrictions on teaching classes that include sexuality content, the district must provide notice to parents that one or more of their students' courses contains sexuality content, and a parent then also has a right to review that content. And then here's an opt-out provision that's new. Parents, if they don't like the fact that a class that their child is in is going to include sexuality content, the parents have the right to remove their child from the class. And then here's a little strange wording to the statute. The parent doesn't just opt their child out of the particular day of the class where sexuality content is going to be included. The parent has a right to not have their child take the class and enroll their child in an alternative class. The legislation is silent on whether or not a school district is required to provide an alternative class. And so that's a little bit of an unknown there. And I think that you'll also, even though the statute doesn't allow for a parent to opt their child out of the particular day of the class where sexuality content is included, you're probably going to have some parents asking about the schedule and maybe just keeping their child home or telling them not to go to class on that day. And that's going to be some fallout that the district will have to decide how to deal with. Next slide, please. So here is the definition of sexuality content. Any oral or written instruction, presentation, image, or description of sexual concepts or gender ideology. I've always found that the phrase gender ideology to be a little bit curious. It's not defined in the law. Sexuality content is defined to exclude certain topics, including venereal disease education, which is another legal term of art. And it basically means that sex education needs to be taught with an emphasis on abstinence. That's really what venereal disease education means in Ohio. And sexuality content does not include instruction on child sexual abuse prevention or sexual violence prevention. But of course, other provisions, existing provisions of Ohio law include opt-out for those types of instruction. Next slide, please. So here's the notification requirement in House Bill 8. District personnel are going to be required to notify parents of any change in the student's services or including counseling services related to the student's mental, emotional, or physical health or well-being, or the school's ability to provide a safe and supportive learning environment. So that language, that phrase in bold text is a legal term of art. And next slide, please. And so that phrase is defined to include these items in the bullet point list. And most of them are, very innocuous. They're likely things that school district personnel were informing parents about long before House Bill 8 was even contemplated by the General Assembly. But the fourth bullet point is really the motivation for House Bill 8. And so here, the General Assembly and when the governor signs House Bill 8, the governor is, going to be requiring school district personnel to notify the parents of a child who makes any request to either identify as a gender that does not align with the student's biological sex. So that's really the what's referred to as the mandatory outing of a student to the parent. That's now going to be law in Ohio. Next slide, please. And just like the legislation that Susan talked about, House Bill 8 does contain a definition of biological sex to include the student's gender as declared at birth without regard to the individual's psychological chosen or subjective experience of gender. Next slide, please. And then here is the final main provision of the original House Bill 8. District personnel, this would include, a guidance counselor, for example, are going to be prohibited from either directly or indirectly encouraging a student to withhold from parent information concerning a student's mental, emotional, or physical health or well-being. Again, that term of art. Not only is a guidance counselor or other district person going to be required to inform a parent if the student starts talking about gender identity issues, but the district personnel are also prohibited from encouraging the student not to inform the parent of that. So I think that this is going to involve, some additional training for district personnel, especially guidance counselors, and maybe, either through that training or perhaps on the guidance counselor's own initiative, the guidance counselor is going to have to, give a caution to students when they're talking to them, and make sure that the student knows that, Johnny, if you bring up certain topics to me, I'm going to be obligated to tell your parents. And it's not exactly clear to me at this point how this requirement to inform parents is going to be applied consistently with the privilege that exists in existing Ohio law that that states that the private conversations between a student and a school counselor are confidential and privileged, and that the student holds that privilege. The new law doesn't address which of these provisions is going to control the other. Next slide, please. The Parents' Bill of Rights also requires a district to notify parents at the beginning of each school year of each healthcare service that's being offered to a student at the student's school, and to give the parent the option to withhold consent or decline any specified service that is available to their student at the school. And then there's also a complaint resolution procedure in House Bill 8. A parent, House Bill 8 doesn't use the word complaint, but the parent may file with the district a written concern regarding any topic addressed by House Bill 8. The district has to establish a process to resolve such concerns. The concern should be resolved within 30 days. And whatever that process is that the district develops, the process within the district must include and end with a right to appeal to the Board of Education. And it's not clear to me exactly at this point whether or not the decision of the board will be appealable to the Court of Common Pleas or not. That may depend on the type of concern that is raised, and also the district's procedure that it establishes to resolve those concerns. Next slide, please. So as Sherry mentioned, there was some dispute between Republicans in the General Assembly about whether release time for religious instruction should be remain its own separate piece of legislation or be rolled into House Bill 8. And it looks to us that release time for religious instruction, is going to pass as part of the new House Bill 8. So current Ohio law, as you may be aware, gives a Board of Education the discretion to enact a policy that allows students to be released from school for religious instruction. But current law leaves that discretion entirely in the hands of the local Board of Education. The board can have such a policy, or it may decline to have a policy. Next slide, please. So the change to the statute involving release time for religious instruction that is likely going to be included in House Bill 8 when it passes is to make it mandatory for a local school board to have a policy that allows a student to leave school and receive religious instruction from a private organization. There are existing requirements in current law for that to happen, and those requirements are going to stay the same. It's just that now if a parent and the sponsoring organization satisfies all of the requirements, then the student must be released. And so the first requirement is the parent has to consent to the release in writing. The sponsoring entity, the entity that provides the religious instruction, has to keep attendance records and make them available to the school. Transportation has to be the sole responsibility of the sponsoring entity, but the sponsoring entity can have the parent provide transportation. That's kind of up to the sponsoring entity. Next slide, please. The sponsoring entity has to make provisions for and assume all liability for student safety once the student leaves the campus. And so that's something that you will need to watch out for. We've seen some contract proposals from sponsoring entities that still have language in them that wants to make the school board liable for any injury that happens to the student. And so if you're presented with that type of a contract, you can either just simply refuse to sign the contract, or you can respond to the entity that those types of provisions need to be removed. No public funds and no public school personnel can be involved in providing religious instruction. Students have to be responsible for missed work, and students, it remains the fact that students may not be released from core curriculum subjects. But I think that Sherry mentioned in the introduction to this part of the talk, or she'll talk about it later, that we may see a definition of core curriculum subjects that we may not be familiar with. Next slide, please. And then finally, a Board of Education, the policy that will have to allow for a release time has to apply to all types of religion. And so you may have heard in the news lately that the Marysville local school district has been contacted by the Satanic Temple, which is a religious organization based appropriately in Salem, Massachusetts. And they are establishing in the Marysville School District a religious instruction program that's sponsored by the Satanic Temple. And it's called the Hellions Academy, I believe. And so, they are going to be pressing the Marysville local school district Board of Education to allow students there to be released. And so just be aware that if you get a request from a Satanic Temple for such a program in your district, that the Satanic Temple is very active in litigation. And so if you decide that their organization is not a religion, they are going to sue you, and you will most likely lose, because courts are not going to be in the business of deciding what is or is not a religion. So that is an interesting factor, an interesting consequence of the General Assembly's plans to require release time for religious instruction. Sherry, do you want to give us some more information about House Bill 8?
Yeah, so a couple of issues. As David said, the legislation doesn't really outline what you can and can't have in your religious release time policy. But what it does say is that the students cannot miss core curriculum. We had districts very quickly move to declare that every subject was core curriculum. And so the General Assembly has stepped in and said, whoa, 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 stop. Everything is not core curriculum. The definition reads right now that core curriculum is reading, English language arts, mathematics, science, social studies, and health instruction. We could conceivably see some amendments today. There is a push because under different definitions of core instruction, foreign language and arts are considered core curriculum, and they are clearly pushing to have those fall under this definition as well, so students aren't missing those classes. But you are going to be required to have that policy in place, and that will encompass your definition of core curriculum that students can miss. The other issue to watch is there's really nothing in this space with regards to your amendments or your policies around requirements of how students are released. Do they have to be signed in and signed out? They are looking at language to tighten up to make sure that it is the parents that are the ones providing the authorization for the release. They are also looking at language around background checks. There has been some issue with a group entity called LifeWise. I think everybody is very familiar with that program. Up in Northeast Ohio, one of the facilitators or teachers that they had hired, coordinators, had a criminal sexual violation in their past, and therefore should not have been in contact with children. So they had not done background checks. They will now be able to be required that you do background checks on individuals who are interacting with these children. So that's with regards to what we're looking at on religious release time. With regards to possible changes in House Bill 8, on the side of the Parents' Bill of Rights, I think the biggest challenge that we're hearing in testimony that districts have concerns over are issues around teaching, actually professional development for your teachers. There is a strict prohibition that was included in one of the sub-bills that says that it prohibits the district or third party acting on behalf of the district from providing instruction that includes any sexuality content to students grades K through 3. Now, I will say that there has been language added that does allow for an exception to this for incidental references to sexual concepts. occurring outside of formal instruction or presentations on topics, including references made during class participation and in schoolwork. So you could very easily see a kindergarten or first grader sitting in class. They're talking about a family unit and somebody references the issue of I have two mommies, and how does the teacher address that? So I think there's going to have to be some very careful professional development in that space that you use to address what your teachers can and can't do. The other challenge that you're going to have is with the federal requirements, I think around PHI, that has been discussed frequently in hearings, as particularly once you get more to the high school age. Now, there is language that says that teachers can withhold this information should the concern be around abuse or neglect. What documentation would be required? I don't think anybody knows. There has been a lot of testimony in this space from individuals who have transitioned in their lives, and they are in the education space and want to provide support to these students. What that's going to look like, I think, is going to be a challenge for you as you do your professional development on those particular topics. So we'll have to wait and see. I will not be surprised to see this bill have a suit very quickly filed against it. As we've had with our Save Women's Sports Acts, our other transgender bills in the state of Ohio, where groups try to enjoin the enforcement of these bills while they are tested through our court system. So we'll all have to wait and see where that comes from or how that comes down over the next couple of years. As I did say, we are waiting for the House or the Senate Education Committee to address this issue. I will indicate that the governor has said that he will sign this legislation should it come to his desk. So any real hope that that he will be a stopgap should this pass the General Assembly, I think is probably wishful thinking on our parts. The other thing I would caution is even if this bill happens to somehow fail to get across the finish line today, I would expect it to be reintroduced very quickly and move very fast through the next General Assembly. The House and Senate will probably take a bit of a conservative turn. We have the Senate President, Matt Huffman, coming over to the House, and he will immediately become the Speaker. Individuals who have provided some breaks in this space has been the current Speaker, Jason Stevens. That break stop will not be in place in the next General Assembly. So even if we hold this off or this doesn't pass today, I do not think this isn't coming. We probably will be required to implement this by July 1st of 2025. The bill does require that it be done by July 1st of the year after it becomes effective, and I would certainly anticipate this bill being effective by June 30th of 2025. So you will be looking at a July 1st implementation date. David, is there anything you want to add from what I've added to this?
No, but I do want to talk briefly about the awarding of credit for religious instruction, because that is something that is maintained from the current law. So even though once House Bill 8 with release time for religious instruction, even though that it looks like that's going to become mandatory to allow that, the change will still retain with the local Board of Education the discretion about whether to award up to 2 units of high school credit for a student who participates in religious instruction. So your board will have to decide whether to allow credit to be awarded or not. The law maintains certain criteria that a board is supposed to consider when it's deciding whether to award credit for a religious instruction or not. Those criteria include the number of hours in the classroom, receiving the religious instruction, what the course requirements are and the materials used, the methods of assessment that are being used by the people who are teaching the religious instruction, and the qualifications of the instructor, which the law uses the word similar. The qualifications of the instructor must be similar to the qualifications of the teachers in your district. So these are criteria that your board will have to consider if it wants to perhaps award up to 2 units of high school credit for students participating in religious instruction. And if we can move to the final slide in this part of the presentation, there is a caution in existing law, which will still be there with the amendment, that one factor or criteria that the board is not allowed to use when deciding whether to award credit for a particular religious instruction program is the actual religious content of the course or the organization's denominational affiliation. So of course you can imagine if the board decided that it was only going to award class credit for instruction in certain types of religion and not in others, that's going to almost certainly result in litigation that the board will have a difficult time prevailing in. And so that's the end of this part of the presentation. So I'm going to turn it over to Aaron and Sherry to present the last session.
Thanks, David.
So as we start to talk about this last session, Aaron is going to cover two different topics. The first topic, I'm sure many of you are aware of Senate Bill 29, which was the data privacy bill that became effective in October. There were some significant challenges with some definitions, and so the General Assembly, as it often does, moved to quickly address those, and they have done so in an amendment that was placed in House Bill 432. I do anticipate there being additional attempts to amend 29 to address some issues. I think Aaron's going to raise them as well. The other issue that Aaron will be discussing is House Bill 106, which is a student expulsion bill that we are still waiting to see if there are additional amendments to. So I will talk about those once Aaron gets done. Aaron, go ahead.
Thanks, Sherry. So I'm going to start off today with the expulsion for actions dangerous to others, which was introduced in the House in June of 2023 and referred to the Primary and Secondary Education Committee. It's been passed by the House, and that happened very recently on December 4th. And the Senate committee in that time has had 3 hearings on the bill. So this bill would permit a school district to develop policy to expel a student for not more than 180 days for actions that pose imminent and severe endangerment to the health and safety of other students or school employees. Now, the unique part of this bill is that it allows the superintendent then to extend that expulsion for 90-day periods based on the superintendent's. It's really their discretion and an evaluation of the student. So when we're talking about the expulsion for imminent and severe endangerment, it's specifically defined in this bill. And it's I would say loosely related to permanent expulsion language, but less severe. So the first would be bringing a firearm to an interscholastic competition, extracurricular event, or any other program or activity sponsored by the school district or in which the district is a participant. The other is bringing a knife capable of causing serious bodily injury to any school property or event in which the district is participating. And then committing an act that is a criminal offense when committed by an adult and that results in serious physical harm to persons or serious physical harm to property. And those serious physical harm to persons and to property are both specifically defined in other locations in the revised code. So we've got specific definitions for what that means. And it has to be while the pupil is on any school property or at any event in which the district is participating. It also includes making a bomb threat to a school building or to any premises at which a school activity is occurring at the time of the threat, or making an articulated or verbalized threat, including a hit list, threatening manifesto, or social media post that would lead a reasonable person to conclude that the pupil poses a serious threat. So in terms of when this expulsion procedure would be available. It's limited to these to this definition. And although we have, 5 different examples of what this definition means, there's definitely some ambiguity in these definitions and when a school district or a superintendent would be able to move forward with an expulsion in this situation. So once a superintendent, proceeds through expulsion for this type of behavior, they have to come up with reinstatement conditions. A superintendent must provide conditions for the student to satisfy prior to reinstatement, which must include an assessment by a psychiatrist, psychologist, or school psychologist, and they're going to determine whether the student poses a danger to themselves, to students, or to employees. Now, I want to be really clear and really emphasize this point that these are not reinstatement conditions, right? These are not conditions that if the student meets them, they're automatically able to come back to school. There is much more discretion built into the statute in the bill for the school district to determine whether that student is ready to return. Now, talking about these reinstatement conditions, they must, the superintendent has to provide a copy of the conditions to the Board of Education, the student, and the parent or guardian. And so, as we just talked about, right, there are an assessment that it's required to be done of the student. And this assessor, right, so it's a psychiatrist, psychologist, or school psychologist. It has to be agreed upon by the superintendent and the student's parent or guardian, so the individual who's going to perform that assessment. There needs to be an agreement there. The assessment must include a determination of whether the student poses a danger to theirself or to other students or employees. And the assessment may include recommendations for contingent conditions of the student's reinstatement. The bill further provides for the assessment costs. As you know, there's going to be costs associated to having a psychologist or psychiatrist do this type of work. So if the assessor is employed or contracted by the school district, then the district is going to be required to pay for the full cost of the assessment. Otherwise, the cost of the assessment must be referred to the student's health insurance, and then the district would be responsible for any costs that would not be covered by that insurance. So after the initial 180-day expulsion period, the superintendent is required to assess the student and determine whether the student has shown sufficient rehabilitation to be reinstated. And like I said before, we've got these reinstatement conditions, but just because they met those conditions, under the statute doesn't necessarily mean that the superintendent, it doesn't require the superintendent to find that the student has been sufficiently rehabilitated. So the decision has to be made in consultation with a multidisciplinary team, which is selected by the superintendent. The superintendent is required to also consider the assessment that was done by that psychiatrist or psychologist and whether the student met those established conditions in the assessment that was completed, or I'm sorry, whether the student met the established conditions and the rehabilitation conditions that were created at the onset of the expulsion. So I think one of the question marks in this bill is what a multidisciplinary team looks like. And I know there was some concern in some of the opponent testimony to the bill about what a multidisciplinary team, what that means and who that is. And that there's no requirement that a parent be a part of that multidisciplinary team or a parent have a say in that process. So that's something that that seemed to get a little bit of traction during the hearings, and we might see some changes to that effect. So if the superintendent determines that the student has been sufficiently rehabilitated, then the superintendent may reinstate the student, and the student can return to school. However, If the superintendent determines that the student has not shown sufficient rehabilitation, then the superintendent can extend the expulsion for additional period not to exceed 90 days. So when they do this, they have to develop conditions to satisfy prior to reinstatement. So those same process as the initial expulsion, and they have to be the same as the, or they don't have to be, excuse me, they may be the same as the original expulsion period. So we don't necessarily need to see different reinstatement conditions here. And then they have to provide a copy of those conditions to the board, again, the student and the parent or guardian. And then at the end of the expulsion period, we kind of go through this process again. Superintendent has to reassess the student in the same manner as the initial, as their initial assessment. They work with the multidisciplinary team. They review the assessment by the psychiatrist, psychologist, or school psychologist, and then whether the student met the conditions. So if the superintendent then determines that the student has not shown the sufficient rehabilitation, they can extend that expulsion for an additional period not to exceed 90 days. And there is no limit under the statute to the number of times the superintendent may extend the student's expulsion. In fact, in the statute, it says that specifically, that there's no limit to the number of times. So you get through 180 days, we do the 90-day extension, and that 90-day extension can be extended again and again and again, based upon the superintendent following that criteria. Now, the superintendent may reduce an expulsion or an extended expulsion if the student has met all the conditions, and then any reduction in the expulsion must comply with your board policy on expulsion reductions. Now, a student or their parent or guardian can request one early reassessment for each expulsion period. So they can make a request to the superintendent to do that assessment that they're required to do. The superintendent is required for each one of those periods to do that assessment if it's requested of them. And it has to be done in the same manner as any other reassessment or assessment that they do for this expulsion process. The superintendent must also comply with the board policy on expulsion reductions for these reassessments if they determine that the student should, they've met the criteria and are good to return to the school. They have to follow that board policy on expulsion reductions. So contingent conditions for reinstatement. The superintendent may develop these type of conditions for students' reinstatement. So they, allow the student to return to the school with these certain conditions that they have to follow. They have to include a duration for those conditions. And that duration can extend to graduation. So it can go, for the entire time that the student remains a student at that school district. Again, those contingent conditions have to be provided, a copy of them have to be provided to the board, to the student and the student's parent or guardian. And then if the student fails to meet the contingent conditions, the superintendent may revoke the reinstatement and extend the expulsion period. So again, you're going through that extended expulsion period process if the student, has not fulfilled those contingent conditions, just like you would for the, after that 180 days where you're going through and determining, whether the student has met the condition when you're considering the psychiatrist, psychologist report, and you're working with a multidisciplinary team. So when the student is expelled, right, not later than 15 days after the expulsion or the expulsion extension, or 10 days for students with an IEP, the superintendent, in consultation with the student and the parent or guardian and IEP team, if it's applicable, they have to develop a plan for continued education. The plan can include district education in an alternate setting, including home instruction, enrollment in another district or other type of public or non-public school, and then any other form of instruction that complies with Chapter 3321 of the revised code. Now, when these expulsions are happening and making any of these determinations, whether it's the expulsion or expulsion extension, the superintendent is required to comply with those normal expulsion procedures, including those time deadlines, written notice, as well as an opportunity to appear before the superintendent to challenge the expulsion or to explain the expulsion, right? And then student and parents also have the right to appeals. A student or the student's parent or guardian may appeal any expulsion or expulsion extension made by the superintendent in the same manner as normal expulsions. So, Sherry, I think you've got something to add here, huh?
Yes, several things.
Awesome.
So the first thing I want to talk about is a possible amendment to the offenses with which you can use this tool in your toolkit. The definition as written right now would potentially allow a superintendent to remove a child who has slammed or broken another individual's cell phone because of the definition of property damage. That was one example provided for in testimony. So they are looking at potentially cleaning up that language or tightening it down. So this is truly only used in those cases where there is a severe threat to bodily injury or to significant property damage. There is some concern that superintendents or that districts could use this language to keep these children out of the classroom for reasons other than safety, which is what this was intended for. Maybe they don't want the individual in the building because of poor test scores, because they're consistently a disciplinary problem, because they're disruptive, and this has provided them with the tools to remove the child permanently from the district or from the buildings, not from the district, but from the buildings. So you could see some language or amendments that are going to try to tie up or tighten down exactly how this process is used. Another possible change is some additions to the multidisciplinary team to include a child advocate and to make sure that that child is being protected and advocated for appropriately each and every time that that expulsion is continued, and making it very clear that there are full due process rights involved when you are making these decisions. There is quite a bit of concern, this legislation came about because we have situations where children have done things like bring a weapon to school. They are expelled for the 180 days. And then regardless of the situation, whether they received treatment, whether they did not, whether there's been any change in circumstances, the child is automatically required to be readmitted to the school district and into the buildings. And this has generated quite a bit of fear, as you can imagine, with both staff and with students. So this is the impetus behind the legislation. But at the same point in time, when you face this kind of flexibility that this is providing, you're also going to face considerable pressure from the community to continue to keep these children out of the classroom. So, I am sure that you are aware that kids all know what's going on and go home and talk to their parents. The child comes home and says, "Hey, Johnny got removed today because Johnny showed us all a gun," and that Johnny's removed for 180 days. And 180 days later, Johnny has had extensive counseling. There's been a lot of work done with this multidisciplinary team. And it's time for Johnny to come back to the classroom and could probably appropriately come back to the classroom. The superintendents will face extremely high levels of pressure, my guess would be, from the community to continue to keep Johnny out of the classroom. So they're trying to balance the flexibility needed for superintendents to keep their students, staff, and community safe, while also balancing the rights of the child to their constitutional rights to a free public education. As Aaron did state, that reinstatement provisions are not set in stone. It is not written such that as soon as the child meets all of those provisions, they are automatically put back into the classroom. So there's concern that those provisions or that process will continue to have something added. Well, yes, you did all of this, but now we need this as well. And then once they meet that, well, now we need this as well. And so there's, I think will be some language around what superintendents could do to tighten up and get children back into the classroom where it is appropriate. There will also be probably some language around requirements on what the education plan is going to have to include that is being developed for the child. Now, currently, when a child is expelled, there is no requirement to provide the education to them during that time frame. But you will under this provision. And what that's going to look like, is it going to be, 1 hour of instruction once a week? Is it going to be 5 hours? Will it be a tutor? Will it be you paying for them to be in an online class? What that's going to look like, they may try to tighten that language up as well. So we'll have to watch for that. And then there also could be some reporting requirements put in where you are going to have to report to the Department of Education and Workforce when you choose to use this disciplinary tool, so that they can track and see where individuals are doing it, how it's being imposed, where it's being imposed, the age of the children, the offenses that it's being used for. So I do expect amendments to this bill. Again, I don't know that it is going to get across the finish line. They are working very diligently to get it across the finish line. But what I would say is, if it does not get across the finish line today, I would anticipate again it coming back very quickly and passing in the next General Assembly. So with all of that, Aaron, I will turn it back over to you to discuss how House Bill 432 addressed some challenges in Senate Bill 29.
Awesome. Thanks, Sherry. So as I think all of us are very well familiar with Senate Bill 29, it was our student data privacy bill, and it required some pretty significant changes in really two areas. First, on how we're contracting with what the bill defined at technology providers, how we were contracting with them, and what our relationship is as school districts with those technology providers. And then on the other side of it was prohibitions on tracking student issued devices. Now, student issued devices was a very general, was defined very generally in the statute, and required, it was more than just our physical devices, right? It was accounts and softwares related to that student for their specific use. And that monitoring piece required a considerable effort from school districts to send notifications to parents whenever these activities were occurring. So the General Assembly really heard these concerns and worked to address a lot of them in House Bill 432, which was signed into law by the governor on December 9th, 2024. There was an emergency provision in the bill, so this bill is effective immediately. And so we're going to see some changes to what we saw from November of 2024. And I'll say mainly the changes are in our notification requirements in 3319.327, which is that monitoring piece. And we don't see as much affecting what needs to be in our contracts for these for these technology providers. So first and foremost, one of the things that I thought was really interesting was the change in definitions. So they changed the definition of educational records to education records. The term is defined as having the same meaning as in the Family Education Rights and Privacy Act. But the FERPA definition is almost identical to what was in the bill initially. So the definition is those records, files, documents, and other materials which contain information directly related to a student and are maintained by an educational agency or institution or by a person acting for such agency or institution. So the definition here is going to be nearly identical to the definition we had previously. And I think that, despite seeing that change, it's going to be very difficult for districts and working with their technology providers to enter into those contracts, because one of the provisions in there that is required to be in those contracts relates to the ownership of student records, and with a very broad definition of student records and a broad definition of technology provider. We've got these situations where the issue of who owns the data and what is a student record is going to become problematic. Now, switching gears to talk about the student data monitoring piece, this is where we'll see a lot of benefit to the school districts based on the changes made in this bill. 3319.327 is the monitoring of school issued devices section, and it provides limitations on monitoring of school issued devices. So, and school issued devices means hardware, software, devices, and accounts that a school district acting independently or with a technology provider provides to an individual student dedicated for the student's dedicated use. So this prohibits electronically monitoring or accessing the following features of school issued device, which is the location, audio or visual, receiving, transmitting, or recording features, and then the student's interactions with that device, including keystrokes and web browsing history. So tracking is permitted if one of the statutory exceptions applies. Those statutory exceptions are pretty specific in terms of when we can do this, and so we'll go through those. But the important part is the bill removes the notifications for the following three exceptions, and the first one I think is really the biggest one for school district. It's when the monitoring is limited to a non-commercial educational purpose for instruction, technical support, or exam proctoring. And so, a lot of what school districts do and a lot of the school issued devices, right, student accounts, student devices, are going to be fitting into this category and really removing a lot of the burden for the school district. The others are when the activity is necessary to comply with federal or state law, or the activity is necessary to participate in federal or state funding programs. So no notification is necessary for those situations. So the district may need to comply with notification procedures if the electronic monitoring or access is permitted under a judicial warrant or subpoena, unless it's otherwise prohibited by state or federal law, or because the school district or technology provider is notified or becomes aware that the device is missing or stolen. So in those situations, notification is only required if the school district initiates responsive action as a result of the electronic monitoring or access. It doesn't really define what is meant by initiating responsive action, and so there's going to be a bit of interpretation that's required there. And then finally, the district may need to comply with notification procedures if the electronic monitoring or access was necessary to prevent or respond to a threat to life or safety, and the access is limited to that purpose, and the district initiates actions in response or initiates actions pursuant to Ohio Revised Code 2151.421, which is reporting child abuse, and then 2 of the suspension and expulsion statutes. And then finally, the 3313.669, which is for threat assessments. So all notices under the statute must be made within 72 hours of the access and include a written description of the triggering circumstances, including which features of the device were accessed and a description of the threat if there is any threat. And then the other big change to notice to mention in this field is the previous iteration of the law required that the notice be sent when there was a life to threat or safety. You could put it off, but you still had to send it. Now, no notice is required when the notice itself would pose a threat to life or safety. So we're not having to follow up after that threat has dissipated and send the notice. No notice is necessary in those situations. And that concludes our webinar, and I think we're open to fielding any questions.
Sherry, I just want to make sure, is there anything you wanted to add to Aaron's discussion?
No, he is correct that that particular provision to 432 became effective immediately. I do think there could be some potential additional changes in that space over the next 6 to 12 months, but nothing that's going to be fast tracked. And I think things that'll be fully vetted as much as they can be in front of the General Assembly to that data privacy provision.
Okay, great. Aaron, I wanted to circle back with you on just one clarifying point. So when you were talking about conditions of reinstatement for the student expulsion bill, so I want to just make clear. So in other words, even if there are conditions imposed and the student has met those conditions, the superintendent still has the discretion to say the expulsion may be extended. Can you just talk
That's
about that a little bit?
Yeah, that's correct. So superintendent is required to have those conditions, but it's not it's not a requirement of the bill that if the student meets those conditions, that they be permitted to return to the school. They can extend that 90-day expulsion period based upon the assessment that the superintendent is required to do. And only one of the factors in that are the conditional or the requirements, those conditions imposed on the student. They also need to, work with the interdisciplinary team, and as well as the assessment that is done by the psychiatrist or psychologist. So all of those things are taken into consideration in determining whether or not to allow the student to return or to extend the expulsion.
Okay, that makes sense. That makes sense. Well, I'm not seeing any questions in the Q&A box, so we've ended a little earlier today than expected, which is probably not ever a bad thing for those of you in the audience. As Sherry mentioned, because the status of so much of this is still up in the air after today, keep an eye on your inbox, and we will be sending an update within the next 24 hours in terms of what actually happens at the legislative session today. So keep an eye out for that. Also, this session has been recorded and will be available on our Roetzel and Andrus website, but you're also welcome to reach out to any of us if you'd like a copy of the recording. We can send that to you. Sherry, David, Aaron, any closing remarks?
No.
Okay.
Nope.
All right. Thank you, everyone, for joining us this morning, and I hope that you all have a wonderful holiday season.